Hello and very warm welcome to you, everyone. Welcome to EBC Learning. Today we will be discussing Mafatlal Industries Limited versus Union of India, and it's our privilege to have with us today Honorable Dr. Justice Vineet Kothari. A very warm welcome to you, sir, from the entire team of EBC. Thank you so much for joining us today. And also, we have with us Dr. Charu Mathur, who is an advocate on record, Supreme Court of India, and also a passionate academician. She has authored various courses at EBC Learning. Dr. Charu has also been conducting AORA courses at EBC Learning. Great to have you here, Dr. Charu. I'll be moderating this session, and we have tried to keep it very interactive. You can unmute yourself and also write your questions in the chat box, and we will take it forward. And I would now request Dr. Charu to please introduce our eminent and honorable speaker, Justice Dr. Vineet Kothari. Over to you, Dr. Charu. Thank you.
Thank you, Dr. Aanchal. Good evening, everyone. Welcome, sir. It is our real privilege and honor to have you. Though Justice Kothari doesn't need no introduction, if you are in this profession and especially dealing with the tax matters, you must have come across his judgments either authored by them or argued by him. But still, just to give you a brief background, sir is not only a lawyer, a judge, but he is a qualified chartered accountant as well as a company secretary. He is a passionate teacher also, and he had in fact taught. He has been part of various journals where he has authored. He has been on the editorial board, not just domestically, but even internationally. He has dealt with domestic tax laws, international taxation, commercial contractual dispute, and for a lot of arbitration and mediation, he is the sought after arbitrator and mediator in the commercial matter. Sir has been acting Chief Justice of Gujrat High Court. For Madras High Court also he was there. He had been to High Court. He has been a judge of 4 High Courts: Rajasthan, Gujarat, Karnataka, and Madras High Court. And he has been acting Chief of Madras as well as of Gujarat High Court. And these days, sir is a senior advocate practicing in Supreme Court of India also. So those who are in Supreme Court, you will get a chance to meet sir in person as and when he is there. And not only that, sir has done his PhD in international taxation. So it is real privilege to have him. He has authored one of the, if you look at Vijay Mallya's Winding Up, that decision had come from sir only. And today we are going to discuss the Mafatlal Industries case. As you know that if you look at the history of Indian Supreme Court, you will find that around 17 odd judgments are there, which are of 9-judge bench judgment. And Mafatlal Industries is one of them. It is in a ratio of 8:1. There is one dissenting opinion by Justice S.C. Sen. And if you look from the point of view of AOR exam, this is one of the leading cases and the most important case, according to me, on the tax laws that is the part of our curriculum. And without taking much ado, I'll just like to hand over the mic to Honorable Justice Kothari sir to come and have enlighten us on this subject. Sir, over to you.
Thank you, Dr. Charu. Thank you, Dr. Aanchal, and all members of the learned audience. It's my honor and privilege to be invited by EBC Learning to share some of the thoughts on Mafatlal Industries case, which Charu rightly pointed out is a 9-judges bench, one of the few, which the Honorable Supreme Court has authored and taken all the great pains to write this judgment. Though the ratio appears to be very simple, but then the kind of research, the kind of material, the kind of arguments they dealt with really shows what hard work goes into making or creating a good judgment. So friends, whatever little introduction has been given about me and very detailed, I would say, I was lucky that I could serve 4 high courts in a tenure of 16 years plus. And now I'm back to the pavilions like a lawyer originally. And tax has been my bread and butter days also in the struggle days and thereafter also when I was practicing Rajasthan High Court and some cases in Supreme Court. So good to be a part of this session. And I would first give you a brief intro of the case and then try to make it interactive, and you can send your queries, or I'll be said by unmuting yourself or by sending in chat box. So I'll try to answer the questions and doubts also. So friends, this judgment of Mafatlal Industries reported, as you know, in the flyer also, 1997-5 SCC, page 536, is a landmark judgment of the indirect taxation. It dealt with the central excise as the subject, core subject, and it was upon reference that the 9 judges bench was constituted to discuss the implications of amendment of section 11 capital B of the Central Excise Act 1944 as it then existed. And as you know now, from 1st July 2017, the Excise Duty Act, Excise Act itself has been merged amongst other 14 taxes subsumed by the GST law from 1st July 2017. And as you know, the excise duty was basically on the manufacture and production of the goods. That was the taxable event under the Central Excise Act. Like the sale of the goods was the taxable event in the sales tax law, and service tax, which was imposed by the Finance Act 1988 provisions, was on the provision of services. Now, GST law has taken into its fold all these various levies of indirect taxation, including sales tax, which later on became VAT, value-added tax, and then service tax and excise duty, etc. Only 6 commodities have been kept out of GST regime on which the earlier laws still apply. That is petroleum products, mainly aviation fuel, petrol, and all these things. 6 things, gas included, where these old laws still apply. So the relevance of not only because this judgment talks basically of the refund of illegal levy of duty or excise duty or tax. Now, though there is a fine difference between duty and tax, but basically broadly the nature is same. Now, refund can occur or can become due to the assessee or to the payer of the taxation for several reasons. So the question which arose before the Honorable Supreme Court in Mafatlal Industries case was that if the refund becomes due, whether the state is bound to refund the tax which was illegally collected by the state from the subject or the assessee. Indirect taxation, as you definitely should be knowing, is a tax in contrast with direct taxation whose incidence or burden is passed on to the customer or next purchaser. So the seller or the supplier who charges this tax from the purchaser or customer does not really bear the brunt. It passes on the burden of the tax along with the price of goods to the next purchaser, who may be trader or who may be ultimate consumer also. In either of the cases, the burden of the tax is not on the seller or supplier, except in very, very few exceptional cases, which we'll discuss a while later. Or what was the shade of that argument which the Honorable Supreme Court dealt with in this case? Now, as you might be knowing, this case was, main author of the judgment was Justice B.P. Jeevan Reddy, with some dissent by Justice CJI Honorable Justice Ahmadi, and main dissent by Justice S.C. Chen, as Charu Mathur pointed out. Now, this is, of course, a very long judgment. So, we used to read it when we were practicing or as judges also. But for this webinar, again, I tried to summarize my thoughts, crystallize those thoughts by reading its head note and some parts of the judgment. So, I'll try to give you some details and insight into the judgment and what is the crux of this ratio decidendi of this judgment. Now, friends, the main issue which was decided by the Honorable Supreme Court by the majority of 8-1 is that even if the refund becomes due for 3 reasons which they discussed and which I'll give you right now, the refund can be made to the taxpayer or seller or supplier of the goods or services only if he proves before the court of law or before the authority concerned of the excise department that he has not passed on the incidence of the excise duty to the next person in the chain, maybe a trader or maybe a consumer. The concept of unjust enrichment, about which we all have heard, was discussed in a great detail. A normal man may understand unjust enrichment as that suppose the tax is retained by the state, which is illegally collected. Why it is not unjust enrichment for the state? When Article 265 is there, that you cannot levy any tax contrary to or without the authority of the law. Then once the court has said that you could not have levied this excise duty or this tax, what is the business of the state to retain that amount? Will it not be wrong? Will it not be unjust enrichment for the state? The court has answered that no. Even if the money illegally collected remains with the consumer or with the purchaser, then state is finally the welfare state covering all. They are supposed to spend tax money for the larger public good, for the benefit of public, for various schemes like infrastructure and all these things. Therefore, the refund of tax, a final seal kind of thing has been put by Mafatlal Industries case, that refund only in the cases where the SSC or the payer proves that no unjust enrichment will be caused to, will be there, and he has not passed on the burden of the tax to the consumer or to the next purchaser of the, in the series of sales or purchases, then only he can ask for refund, otherwise not. This simple ratio has been discussed from various shades of the arguments which were raised before the Honorable Supreme Court Constitutional Bench of 9 judges. Now, in what 3 contingencies the Honorable Supreme Court said that the levy of the excise duty itself can become or can be said to be illegal or unconstitutional. Number 1 situation was that the provision itself, which is under challenge before the court, is declared to be ultra-vires or unconstitutional. There are fixed certain parameters on the basis of which any provision of any parliamentary law or state law can be declared to be unconstitutional, like the legislature does not have the competence to enact that law. It is violative of Article 40. It is against the constitutional basic features or values. Then it can be struck down by the court. Now, if the provision concerned has been struck down as ultra-vires or declared unconstitutional, then of course the refund can be given. And there, on the question of remedies, I'll discuss further. The court, Honorable Supreme Court, this bench, left it free for the SSC to choose the forum, whether going before the same excise authorities or before the civil court for by way of civil suit, or even writ petitions for refund of that unconstitutional levy of excise duty which has been collected or recovered from the taxpayer. The second contingency which the court talks for holding that excise duty is illegal. These words, you may kindly note the fine difference: illegal, unconstitutional, ultra-vires, and mistake of fact or mistake of law, which is the third contingency, is a fine difference, but they are defined differences. The second point on which the refund of excise duty can become due to the assessee or to the taxpayer or to the seller or to the manufacturer rather, who produces the goods, where the claim for refund is based on the ground that there has been misinterpretation, stroke misapplication, stroke erroneous interpretation of the Excise Act, rules or notification, or an erroneous finding of fact, or in violation of fundamental principles of judicial procedure. Now, this is itself a big area of courts applying their mind and holding that a particular levy of excise duty has been or was levied illegally or is an illegal levy. So, first is unconstitutional levy, second is illegal levy, third is mistake of law. Now, mistake of law is what? Where the claim for refund is based on decisions rendered in another case holding the levy to be not exigible in law or without jurisdiction or illegal or unconstitutional. Now, suppose you are an SSC, you do not challenge that levy, but somebody else challenges, and the court declares in his case that it is illegal in these kind of situations or these fact situations, this excise duty could not have been levied. Now, whether you can take benefit of that decision or not is this third aspect. Then it should be deemed that you paid that excise duty under a mistake of law, which you thought is a good law. But later on, court says in another case, it's a bad law. So if it is a bad law, then of course, again, it is a mistake. Then section 72 of the Contract Act, which says restitution of any money paid under mistake. It does not talk of mistake of fact or mistake of law. But the Honorable Supreme Court in this case said it does not matter whether it is mistake of law or mistake of fact. Mistake is a mistake. Section 72 is retroactive. So these are the three kinds of illegalities or mistakes or violation of Article 265 of the Constitution of India, which gives rise to the issue of refund of excise duty. Now, what was the case before the Honorable Supreme Court? What was the reference? The reference was that Section 11 capital B was amended by the legislature in the year 1991. They said 11B talks of claim of refund of duty. Now, in the one of the provisions they inserted there that the SSC claiming the refund will have to show that he has not passed on the incidence of tax to his purchaser or the consumer. Now, this provision was challenged before the court of law. And on this, reference reached up to 9 judges bench in Mafatlal's case. And the court upheld this amendment, saying that it is a valid provision, it is a valid embargo, it is a valid block on the right of the SSC to get the refund unless he shows that there will not be any unjust enrichment and he has not passed on the incidence of the excise duty part, the tax component of the price of sale of goods. This burden of proof was cast upon the SSC or the petitioner to prove while claiming the refund, and this amendment was upheld by the Honorable Supreme Court. So the main crux of the issue which came up before the Honorable Supreme Court was whether this amendment putting this embargo on the SSC to claim the refund of the excise duty, which is admittedly or on the face of the law as exists on the record, either provision being declared ultra vires or some other judgment declares that levy illegal or a mistake of fact or law has arisen in the case. Now the Supreme Court turned to the remedies part. What can you do if you find that excise duty paid by you was illegal, unconstitutional, or was under a mistake of fact or law? Obviously, we will go to some authority or to some court of law to seek that refund. Now, the judgment of this 9 judges bench has made two types of distinction. One distinction rather. They said that in the cases of unconstitutional levy, if the provision itself has gone away from the statute book or has been declared ultra vires, all remedies are open to you. You can go to the authority concerned, you can go to the civil court, you can go to the writ court. And you can, on that, Justice Jeevan Reddy was of the opinion that you should go to the authority concerned. But Honorable CJI Ahmadi said, no. If once the declaration is given about the ultra vires nature of the provision, they should be free to avail their remedy for the refund. But the limitation part was still there. Now, in the end, in this judgment itself, they have given some laxity about limitation when the declaration of law being ultra vires is made. Then only naturally we'll come to know that this provision is invalid under which I paid the tax. Now, excise law, as you know, was commodity based. There were several classifications. HSN code applied. And the classification dispute itself was a very big area of disputes or litigations, like in sales tax law. So during my practice days and this editorial days, when I used to edit a journal called Sales Tax Journal, I said this is a big chunk of litigation. Why can't they have a simplification of all this? Why can't you reduce the classification of the goods, be more clear about it, etc., etc. These kind of things I used to write. After those articles and editorials, this VAT philosophy came in 1990s or so. About GST also, just a slight deviation I'm making deliberately to give you an overview of this indirect taxation system. GST law also was claimed and acclaimed and is still being claimed to be very big indirect tax reform. Yes, it is undoubtedly a tax reform because cascading effect of the taxation is sought to be removed during VAT days also, during GST also. But GST, as you know, is wholly a technology-based, soft technology-based machinery is required for implementing GST law. Now, all this, in my respectful submission, though it is a simplification, but it is not the simplification of the dreams of the tax people who know the tax jurisprudence. In my opinion, there could have been only one simple GST law. Pay tax this much in fewer slabs, pass on the incidence, take the credit of that. Input tax and zone. Now this IGST, SGST, recompense or recuperation of the loss suffered by state, etc., all this has happened more because of political differences between the different states. And this is slightly an area which still requires a debate. And second aspect is that technologically, perhaps India was not fully prepared. So the implementation hiccups of the GST law from 2017 are still being felt. And various amendments after amendments keep on coming in, rules and notifications keep on coming, which is, of course, the tax experts and tax advisors making their heyday, but that's difficult procedure even for them. So what to talk of a simple trader? Now coming back, now GST also has refund provisions, input tax credit provisions. So a natural question can arise whether the Mafatlal Industries case applies to GST law also or not. Yes, why not? The concept of indirect taxation is the same under GST law and excise law. Only the taxable event thing has been broadened and consolidated in GST law. In excise law, it was manufacture or production of certain commodity. And as we understand in tax laws, manufacture means if you make the thing or raw material of a different commercial value, different article, there is a change in the substance of that raw material, then it amounts to manufacturing. And the moment you fall within the definition of manufacture, excise duty is attractive. If the commodity in the same form is purchased and sold, excise duty act does not apply or did not apply. Sales tax law or VAT law. So that was the fine difference between manufacture and sale of commodity as such. This difference, coupled with supply of services, which our IT sector, as you know, India has done so wonderfully well worldwide, that on software, on computers, we provide from here the codes and service packages and the programs and this and that, so many things. This was within the definition of supply of services. There was no sale of tangible goods. So it could not fall within the definition of goods. So Article 366(29) capital A was amended. Entry 54 was also amended, list 2. And after all this 101st constitutional amendment law, these GST enactments were enacted by the parliament and then finally enforced on 1st July 2017. So this judgment of 1997 of Mafatlal Industries case definitely applies to GST laws also, because the concept of unjust enrichment, illegal levy, unconstitutional levy, mistake of fact or law still are concepts of tax jurisprudence or even common law or civil law, which is very much there available in the tax laws also. Therefore, nobody can say that this judgment was only prior to 30th June 2017. It will not apply now. It applies with all force even now. And I'll give you one judgment of the Bombay High Court, which I was recently studying, that they have allowed refund on the ground of GST being not leviable on the export of services. I can straight away come to that. I'll come back to my main point again here. Just to give you a better idea of what is difference between excise duty and GST and how despite Mafatlal Industries, how the SSC there in Jar Productions versus Private Limited versus Union of India, the judgment is as recent as 9th of June 2022, delivered by Division Bench of Bombay High Court. Very interesting judgment. So I'll give you a brief bird's eye view of that judgment right now. That judgment talked of, they referred to Mafatlal Industries also, and then they said that in the agreement between the parties, of course, the GST law said that on the export of services, no GST will be leviable because then there are constitutional problems, Article 286. And if the supply of the services given to a foreign buyer or consumer could not be taxed, then the GST was not leviable, but they paid under protest. The agreement between the parties said that if you apply for refund of the GST and get the refund, then that refund will be reduced from your cost of services to us. And ultimately, we, the purchaser or consumers of the services, will benefit out of that. So even initially, while paying, the SSC before the Bombay High Court, Jar Productions Private Limited, collected the duty and passed on the incidents to the foreign consumers of UK. They got the refund on the ground that export services could not be taxed. They got the refund as per their own agreement was to be reduced from the total billing of the consumer. Therefore, the court said that it is illegal to collect this levy, and Section 54(8) of the CGST Act they referred. And export of services being not taxable, they directed the refund of the GST amount to the SSC petition before them. They referred to their own earlier judgment in the case of Motilal Oswal Securities Limited versus Commission of Service Tax 2016, and also of course referred to the Mafatlal Industries for unjust enrichment aspect, but they still held that since it was not, the refund was not to be retained by the SSC petitioner, but was to be reduced from the cost of production. Therefore, the ultimate benefit would be going to the consumer or the UK company. Therefore, this refund is justified and Mafatlal Industries will not hit this refund. So this is how the law not only develops with the contractual terms, with the international trade practices, with the different bylaws and notifications which keep on coming. And that is why in tax laws, we have to update ourselves on day-to-day basis. As I said earlier, in GST law, since the law is developing, though the concept is internationally now almost applicable to all bigger developed economies, etc. But then in India, it is developing more because the Indian traders or smaller manufacturers were not even fully prepared to switch over from VAT to GST and service tax to GST. Now, the net of the GST is also very wide. Of course, it has become far easier now to pay GST to the state concerned, where from the supply or sale begins under SGST Act, which is perimeter with CGST Act, and the half portion. Half portion goes to state, half portion goes to CGST, and the revenue is collected by the person concerned. He gives the GST invoice to the other party, who can take credit of that GST levied by his supplier and paid by him against his further supplies. to his purchase or customers. So this is the concept of passing on the incidence. And this is concept of other side of the coin for the unjust enrichment also. The incidence which you have passed on, whether a refund from the government to you, that will amount to collecting the duty from both ends. While you pass on the incidence to your purchaser through invoice, you collect the duty. If you get the refund from the state, you again get the same thing. So it is undoubtedly in 99% of the cases, it will be unjust enrichment for the assessee to get the refund of the duty part which he has passed on the incidence. And that was the main controversy. Now, for doing this so-called small thing or small ratio, the Honorable Supreme Court had to write more than 500 pages, which are printed also about 200 pages. And they discussed some of the leading foreign judgments also. I'll give you an idea of the foreign judgments also. And where Justice Swasi Sen agreed with an Australian High Court judgment, which is Supreme Court equivalent there, and they said, nothing doing. If it is unconstitutional, don't ask questions. Refund the whole thing. But then the court said no. Following some US, UK judgment, etc., common law to which also belong. They said that the chaos in the public finance, chaos means you deposit this duty to the state treasury. Their spending is constant. They do not retain the money for your payment in the coffers, just like that. Therefore, the state is presumed to be constantly spending tax money for the larger public good. So if you get back that money, what happens to that expenditure? Therefore, that is called chaos in the public finance system, which framed a valid ground for the court to say that unjust enrichment of assessee vis-a-vis unjust enrichment of a state, the rights of the interest state deserve to be protected. And that is what a fine distinction was drawn following some foreign judgments, which we will just discuss briefly. So the foreign judgments which I am talking of, I'll give you a brief kind of idea to you, because you are all young advocates becoming AOR or trying to become AOR. So I think it's of interest to you to look into. And foreign judgments also, the jurisprudence is almost the same, but their reasoning, their way of thinking, their way of writing is slightly different. And sometimes new thoughts can occur to you if you read these judgments carefully. In Air Canada versus Queen in right of British Columbia, the learned judges, including Wilson J., who dissented on one issue to be indicated shortly, looked at the claim of refund of taxes recovered contrary to law from two standpoints: constitutional law and law of restitution, section 72 and ultra vires concept. They held that the distinction between mistake of fact and mistake of law should play no part in the law of restitution. Further, that the rule of taxes paid under mistake of law are not recoverable should have no place in constitutional law. But the Supreme Court distinguished this Canada judgment on the ground that it talked of direct tax, income tax, which is direct tax, which goes from your pocket, and if you are entitled to refund, you get back into your pocket. The basic fundamental difference between indirect tax and indirect tax should always be remembered. So this judgment was not held to be applicable. The judgment which Justice Swasi Sen followed was in the case of Commissioner of State of Revenue versus Royal Insurance Australia Limited. That is a 1995 judgment which came before the court. The court said, the Australian High Court rejected the plea of the state that inasmuch as the plaintiff has passed on the burden of illegality collected tax to others, it is not entitled to restitution. Mason CJ observed as in the High Court. The argument that a plaintiff who passes on tax or charge will receive a windfall or will unjustly be enriched if recovery from public authority is permitted rests at bottom upon the economic view that the plaintiff should not recover if the burden of the imposition of tax or charge has been shifted to third parties. In the context of the law of restitution, this economic view encounters major difficulty. The first is that to deny recovery when the plaintiff shifts the burden of the imposition of tax or charges to third party will often leave a plaintiff who suffers loss or damage without a remedy. That consequence suggests that if the economic argument is to be converted into a legal proposition, the proposition must be that of plaintiff's recovery should be limited to compensation for loss or damage sustained. The third is that an inquiry into and determination of loss or damage sustained by plaintiff who passes on the tax or charge is a very complex undertaking. And finally, it has long been thought that despite Lord Mansfield's statement in Moses versus Macfarlane, the basis of restitution relief is not compensation for loss or damage sustained, but restoration of the plaintiff of what has been taken or received from the plaintiff without justification. This was the view of Australian Chief Justice Messenger, which Justice Suwasi said in this dissenting opinion adopted and said, if it's illegal, it's illegal. You pay it. Forget it. You are a mighty state. How can you retain taxpayers' money? But unfortunately, that principle is a minority opinion, and that principle is not as sound as the Mafatlal majority said. A individual SSC versus a welfare state. The balancing of equities is also necessary job of the courts. That is why they said that for other two aspects, illegal levy and mistake of fact or law, you will have to go back to the authorities of the department. You cannot approach the court of it because it is a question of fact necessarily involved there. You will have to show when did you charge, when did you make the invoice, when the payment was received, whether the incidents had been really passed or not. These are all facts within the special knowledge of the SSC or supplier or petitioner. Therefore, this proving business, leading evidence, showing claims, etc., revenue having right to rebut that also has to be taken by the authorities concerned. Only when the provision is declared unconstitutional, because that is none of the business of the authorities to either uphold the validity or declare it otherwise also. That's a well-settled proposition which all of you are aware. So if only a provision has been declared otherwise under which the levy was made, then Article 265 is directly hit and remedy is open to you, even to approach a court of law, in writ court, civil court, or authorities of the department, whatever. This option has been given. Now, friends, I was talking about the hard labor put in by the honorable judges. They discussed in para 310 almost 7 articles or 8 articles by leading foreign authors of the world on the question of restitution alone. I'll just give you an idea of that. When money is paid in pursuance of a void authority, a duty to repay by Peter Burke's Public Law 1992. Of course, there are 1997 these judgments there. So all these articles are prior to this. Even now you can find many articles in Google. Restitution of taxes, levies and other imposts, defining the extent of Woolwich principle by J. Bitton, Law Quarterly 1993. Restitution of overpaid tax, discretion and passing on by J. Bitton, 1995. Unjust enrichment, Steve Edley, Cambridge Law Journal, 1995. Unjust enrichment claims, a comparative overview by Bryce Dixon, 1995. The law of taxation is not an island. Overpaid taxes and law of restitution by Graham Virgo, British Tax Review. Payment of money under mistake of law, a comparative view by Gareth Jones, Cambridge Law Journal, 1993. The restitution, misdirected funds and change of position by Ivan McKendrick, Modern Law Review, 1992. All these articles have been discussed in little more detail, but I need not bother you with all this. In the end, the Honorable Supreme Court gave a format order, which actually, if you pick up this 1997 5 SEC, just after the print of this Mafatlal Industries, starting from page 536, ends on page 743. So approximately 200 plus pages. The Honorable same bench of 2 judges, then B.P. Jeevan Reddy and Justice K. Venkateswamy, in another case, quoted that format order. I'll just briefly refer to that so that you can almost have a summarized view of the Mafatlal Industries case now. They said in the second case which they dealt with, pursuant to directions given in Mafatlal Industries, the appeals or special leave petitions coming up for disposal shall be disposed of in terms of one or other of the clauses below. Where a refund application was filed by the manufacturer or purchaser beyond the period of prescribed under Central Excise Act or Customs Act, in that behalf, such petitions must be held to be untenable law. So, ground of limitation was kept open. Even if in appeal, suit or writ petition, direction has been given that refund application shall be considered without reference to the period of limitation prescribed in Central Excise Act or Custom Act, or that period of limitation shall be taken as 3 years, such a direction of the appellate court or civil court, high court shall be deemed to be unsustainable. This is very important. Please mind it, that even if the high court or lower court or authority has said limitation will not apply, forget the exception of unconstitutional for the time. Limitation will apply even if there is such a direction that will stand overruled. The period prescribed by Central Excise Act or Custom for filing refund application in the case of illegal levy cannot be extended by any authority or court. However, where a refund application was filed within prescribed period by the Central Excise or Custom Act but has been dismissed wholly or partly on any ground, or said order is questioned by way of writ petition or suit or an appeal arising therefrom, the manufacturer or purchaser shall be entitled to withdraw that petition, suit and appeal arising therefrom, as the case may be, and file an appeal before the appropriate appellate authority within 60 days. So what I said earlier, that if it is illegal levy or misinterpretation or wrong application of law by a court decision or a mistake of fact or law, second and third category of 3 aspects, then you have to go on in these circumstances to the concerned authority of the department, like tribunal, a commission of appeals, and the assessing authority. There are 3 hierarchy of these people. So in these cases, you will have to go to the authorities concerned only and not writ court or suit. Third, where however a writ petition or suit claiming refund was filed directly in the High Court and Civil Court without filing a refund application, the petitioner plaintiff shall be entitled to withdraw the writ petition, suit, or any appeal arising therefrom and prefer a refund claim under Section 11 capital B within 60 days from today, provided that the writ petition or suit was filed within the period prescribed by Excise Act or Custom Act for filing refund application. It is clarified herewith that even in a case where such writ petition has been allowed and appeal filed by revenue is pending, the writ petition shall be entitled to withdraw the writ petition, in which event the revenue appeal shall be disposed of, permitting the writ petition to withdraw the writ petition to pursue the remedy proposed hereby. Fourth, the above rules, however, do not apply in case of claim of refund for duty levied and recovered under unconstitutional provision. In such a case, the period of limitation shall be as prescribed in Mafatlal Industries, the duty to allege and prove that the duty has not been passed on to another person, of course, remains even in such a case. Where that means even if the provision is ultra vires, you will still have to show that you have not passed on the burden, unjust and ineffective. 5. Where a person challenges the constitutional provision in the Central Excise Custom Act in the High Court, but fails in his challenge to constitutionality, he cannot take advantage of the decision in the case of another person striking down the said provision as explained in the judgment. This rule is evolved in the particular context of refund claims under these 2 enactments as to be observed. Now, this is very significant. The court has said as one of the ratio decision that if X applies, challenges the same provision and fails, so his judgment is sealed. Y applies on same grounds or other grounds, he succeeds. The provision is declared ultra vires. Still, X cannot say later on, after Y's judgment, that now the provision is gone, give me the refund. No. Judgment in personam. Your fate is sealed by your judgment. Forget the refund. Now, this was a distinction which they made only for excise duty and custom law, because again, of course, like indirect taxation, they are indirect taxation, but they said this will have to be followed. Perhaps in their mind was working the same chaos of public finance. 6. Where a refund application or an appeal is preferred under the accordance with directions 1, 2, 3 above, the same shall be entertained only if the applicant for refund appellant files affidavit stating that he has not passed on the burden of duty which is claimed by way of refund to another person. In case of applicant for refund is a company or society, the affidavit shall be sworn by the managing director or principal officer of the company or society, as the case may be. Such an affidavit shall be treated as an averment assertion which an applicant for refund has to make in terms of judgment in Mafatlal. So if specific affidavit will have to be filed. Where the refund claim is rejected by the court, the SSE has already obtained a refund. Any amount by way of refund shall be liable to pay back. They have gone to this extent. That whatever has been paid in the meanwhile when this litigation was going on, you will have to pay back. If the refund claim is rejected by an authority under the Act, where the SSE has already obtained refund, he shall be liable to pay back the said amount to the department according to law, and department shall be entitled to recover the said amount. But so these were the conclusive part of things which they reiterated in another subsequent judgment, which is printed here in SEC. To summarize, friends, then I'll invite queries. The judgment of Mafatlal Industries says that under excise law, Section 11B amendment of 1991 is valid, which put an embargo and restriction to claim refund from the department on the ground of levy being declared illegal. The illegality can happen in three aspects: the provision being declared unconstitutional or ultra vires. Number two, there has been a misapplication or misinterpretation of the relevant provisions or rules or notification. Third, there is mistake of law or mistake of fact. Mistake of law may arise from subsequent judgment of the competent court, or mistake of fact can be there on the facts of the SSE himself. These three mistakes can give rise to a illegal levy being made by the revenue department, which prima facie would attract violation of Article 265 of the Constitution of India and Section 72 of the Indian Contract Act. Now, those refunds can be restricted on the ground of unjust enrichment to the taxpayer or SSE or the petition before the court. And that amendment has been held to be valid. So the net conclusion is that unless you prove that you will not be unjustly enriched by such refund, you never passed on the incidence of the tax to the consumer, you will not get the refund of excise duty. The same theory and principle applies to GST. One deviation or difference which I pointed out to you in Bombay Division Bench judgment was that the agreement between the parties said that refund of GST, if any, will go to reduce the cost of supply to the consumer, was held to be a valid claim of refund, and the Division Bench of Court has allowed that, subject to, of course, what Honorable Supreme Court says on that. Now, this is my take on the understanding of Mafatlal Industries case. I go back to Charu and Madam Dubey. If there are some queries, even I can look at the chat box, or if somebody wants to interact with me, it's welcome.
Thank you, sir, for such an erudite lecture on such a difficult topic that we find those of who are not coming from the text background or who have not done. And
I hope I was not very complex like the text.
No. And the way you have explained it along with the GST and applicability of 1997 ruling in the present time, that makes us very important. So if there are any queries, please ask.
Chat box does not have so far anything.
Yeah.
I can take it like the things have gone overboard.
No.
But I hope people have understood. As I said in the beginning, it's a simple ratio, but very elaborate research and principles laid down in this judgment by 8:1 judgment of Honorable Supreme Court. And what a beautifully written judgment it is.
Yeah, certainly it is. So, guys, if you have any
Arun Kumar Agarwal Saab is on the screen. Yes, Mr. Agarwal.
Good evening, sir. May I ask one question? Like,
Yes,
if suppose I am, like you said that same principle will apply in the GST also.
Yes.
And if suppose today I am a manufacturer or trader, and I am of the view that the GST being applied on this product or service is not correct levy. And because for the time being, I'm regularly doing business, and I don't want to burden my customers. So either I don't show the GST separately in my bill, I charge the amount including GST, consolidated amount, or the alternatively I state on my invoice that we are charging GST under protest, and if in future this amount is refunded, we will refund to you. So whether this declaration in the invoice
this declaration will be taken as a device and may not sustain, because first of all, if you do not show the GST separately in the invoice, the next fellow will not be able to take its input tax credit at all.
Okay.
You have to not only show, you have to pay to the state component, to state CGST component, to a different account of treasury. So the credit, the deposit of tax is already there. And once the incidence of pass is passed on, as you yourself are saying, I will raise the invoice and pass on. But with the stipulation that if I get a refund, I will pay back to you. This will lead to a kind of chaos again, where a series of transactions has taken place up to, and say 10 people have got this thing. Then the state cannot manage that. This was also discussed in this judgment, that unmanageable chain of supplies and sales will render it virtually impossible for the state to see that the benefit ultimately reaches the consumer who had suffered the burden in the first instance. Therefore, stop it there.
Okay, no, but you see, in case I could not state the facts fully, my total sales are to the end users.
Only direct to consumers.
Direct to consumers. So they are not claiming any input, number one. Number two, whether such a declaration before the customer would tantamount to a contract attracting section 60.
No, sir, because the problem is that the law only says that if you have passed on the burden, so a declaration is only like a hedging or a stipulation for your self-serving thing. Suppose you take back the refund and do not give it to the consumer, where the consumer goes, who may be hundreds in number.
So how the Bombay High Court judgment, where the GST between
that is what they said, that this will go to reduce the cost of production, which suppose in the next invoicing they will say, all right, you got this refund X amount, in the next we'll reduce the X. So that was part of the agreement which the court sanctified. So I am still saying that this, again, revenue will not going to leave this judgment easily. This will be taken to Supreme Court. So whether this agreement stipulation, like your invoice stipulation as you are talking about, which can also amount to agreement sometimes.
Yes, that is my point, whether that will amount to agreement
but
or not.
This may, in my humble opinion, can be taken to be only a device to let your payment be made under protest, and then take it back from the state, and then who will control whether you pay back to your customers or not. Here, perhaps it was one party agreement, one X to one Y, and they said this will form part of reduction of.
But this issue, whether I will reduce my cost in the next invoice to the export customer, will also arise there.
You file returns. Your assessing authority is always there to check this.
No, but my point is, even in the export sales, you see, the GST is charged on sales amount. So whenever a next bill will be raised, I cannot pass on the input GST in the next sale invoice.
So your question has two basic deficiency, I would say, with great respect. That firstly, you say I do not show GST separately in my invoice is, I don't think, a permissible thing to do. And even if you are doing that and you are selling directly to consumers, the very thing that you give this stipulation in the invoice will not be believed. Therefore, your chances of getting the refund of GST on this ground, on your own interpretation, Now, your interpretation versus revenue interpretation is a subject matter of litigation. Some court of law, that to a final authority like Supreme Court, has to say that this is illegal. And as Mafatlal said, even it is held to be illegal, go back to square one. Claim your refund there.
So your point is that whether I will be refunding the money or not, it will depend. It will depend upon the facts of the case, which
facts of the case. Therefore, they are not permitting this kind of.
But if I am able to show to the lower authority that yes, this is the party available, I have addressed contact details.
Problem is at the beginning point. You should not have passed on the incidence of the tax. Once you pass it on, your subsequent undertaking that I will pass it on to my consumer.
But sir, the problem is if I am doing business for a margin of say 2 or 3%, and the GST rate is 18 or 28%. So can I conduct my business with such a huge tax, paying from my own pocket? If my turnover is say
that with great respect is a matter of representation, as you know. You can't say my business profit is only 3%, therefore rate of tax is very high. All right, go to GST Council and say.
Okay.
That courts have no business to intervene.
So, but my main point asking you a question was that whether the declaration on invoice can be held as a valid contract under section.
I don't think so. I don't think so. It can
okay. Okay. That was my point to understand.
Yes.
Thank you. Thank you.
Sir, yeah. Go ahead, Vineet.
Yeah. Yes, ma'am. So my question is with reference to that American case where you spoke about chaos in public finance system. So there might be some deficiency in my understanding. So I would request you to shed some more light on that. That if we stick to that concept of chaos in public finance system in this context, with reference to one person. No. Let me complete.
Yes.
So is it not comparing apples with oranges? Because see, if we talk about state finance and come to the principle of budgeting, see, even the state finance is a different scale of things. And how can one SSC be pitted against the state in this manner? So can you please explain if I'm misunderstanding?
No pitting against SSC against the state. It is just a matter of balancing the equities.
Okay.
If you argue that the state will retain this tax, which is per se illegal, which the courts have said to be illegal, why not I should be allowed to have unjust enrichment? Why state? Then they say, no, the state is a different entity altogether which spends money on general public.
Okay.
You will have it as a profit. And there the money already stands spent up. Suppose you pay tax today, after 5 years you become entitled to this refund. Your money is not lying in the coffers separated. Therefore they said it will create a chaos. And this was the word used in that English judgment. But finally, the principles of unjust enrichment and that are almost akin, cousins, like I would say.
Okay, so in this case, in this English case, yes, equity has been used as a shade for the state, is it, in taxation matter?
Yes.
Okay,
and the principle is that there is no equity in taxation.
Right, sir. Exactly, sir. Right. Thank you.
Equity in taxation is a principle for levy of taxation. It is not for refund of taxation.
That's a very nice, fine bifurcation. Thank you so much.
That is why they said unjust enrichment of state is permissible. But unjust enrichment of individuals or corporates we will not permit.
Very well. So this is very refined point. So thank you very much. Yes, quite a learning.
And that is why you see, equity and taxation are not enemies. They may be strange bedfellows, but they are not enemies. So state versus individuals, in cases like this, brings in the principles of equity also. What is limitation? It's a question of remedy.
Right.
Court said the limitation of law will apply even if you are entitled to refund. Except in the case of unconstitutional thing, which we are saying 6 months from now, you go.
Okay.
Otherwise, limitation is there.
Thank you. Thank you.
I think Mr. Sir Vijay Goyal ji and Mr. Prakash Ranade, 2 more queries are there.
Yes, Mr. Vijay Goyal is a very dear.
Yeah, Vijay Goyal ji, you can start. You can even ask.
Mr. Vijay Goyal, what is your chat, sir?
Yeah. Yes, sir. This point is like in case of a captive unit of a
Yes.
foreign company, where I am compelled to pay the taxes, indirect taxes,
Yes.
under some demand. However, I contest that, and finally, I hope to win that case in my favor. So now my concern is here in reference to the unjust enrichment. Actually, see, when I pay X amount to the department, where do I show in my books of account? There are two options. One is that I park this as amount recoverable from the department in the balance sheet as an asset. The other possibility is that my auditor will say that on the conservatism principle, you book this as a cost. Right. So if I book it as a cost, I'm a cost plus entity.
Yes.
So I recover it from my customer.
There is a fine distinction, sir, with Peter. You are also chartered accountant, I know. But the passing on the incidence in the form of the cost plus is different from passing on the incidence of the tax. If you are passing on the incidence of the tax as tax,
okay,
then the refund will cause you unjust enrichment. Right. But if you debit it to your trading account or say manufacturing account and it becomes part of the cost, you sell it to your consumers, you will not be said to be passing on the incidence of tax. And firstly, if I correctly understood your query, you say that if a demand is raised,
right,
I have to pay it under protest, subject to my litigation.
Right, sir.
Then you are not apparently charging that tax in your invoices to your customers. Therefore, it is not a case of passing on the incidence. Even if through accounting entries you form part of cost and indirectly you raise the cost plus bill to the your purchaser, then it will not amount, in my understanding, passing on the incidence of the tax.
Okay, sir. Right.
And that is what seems to be the logic behind division bench of Bombay.
Right. Okay.
In the cost, they said cost reduce, you pass on benefit to me. The court said this is not, he is not retaining the money. This is proved by this agreement.
Right, sir. I
And
think
they allowed it.
Yeah, very fine distinction, sir. Thank you so much.
Yes. Mr. Prakash Sinha, you are on the screen. You want to ask something?
Yes, sir. Good evening, sir. This is Prakash Sinha, sir.
Yeah.
Yeah. My first question is on the point which Vijay sir has raised here.
Okay.
And I have the second point, which is an independent question on that point here. So in the first point, we have seen that in many cases, the refund application has been rejected by the department, saying that you have booked the taxes in your cost here, and it is not showing as a refund receivable in your books of account. So it will be, this means that you have passed the incidence of taxes here, and therefore you are not eligible for the refund here. In many cases, I have seen the department order like this one here.
Okay.
I appreciate the distinction mark difference that you have already raised here, but particularly in my short life of the litigation, I have not seen this type of department taking this type of a stand, or the SSC taking this type of stand.
In my short or long life, whatever you call it, I've also not seen any of the tax authorities giving you benefit in the first instance.
Yes, sir.
Invited to Supreme Court.
Yes, sir.
That is unfortunate part of it. But then you see, principles of law we are talking about. What authorities can do or will do is known to all of us. With the kind of structure they have, they consider as their own risk on the service carrier if they can't refund to you. Therefore, it is they feel it is their duty to reject it.
Yes, sir.
And whatever you want. But you will, in law, the law of evidence is very clear. Law of proving the facts is also very clear. And when the tax will be said to be passed on to the customers is also well known thing. The question is of proving. And therefore, they said that if you prove that you have not passed on, then you are entitled to refund. If you cannot prove it, then all equity considerations, limitations, etc., will apply. So virtually, this judgment has rendered refund a dream. Because revenue authorities will have several kind of things, as you are saying, that even you have booked it as a part of cost, they will say, no, you have booked a cost, therefore you have to passed on. But then, in principle, you have not really passed on. Tax is tax, just.
And the second question is that is very interesting, sir. is on the income tax front of view here. Income tax, there was a erstwhile section was there under section 239, where a person has paid the advance tax wrongly can claim the refund here. But that section has been right now says that unless you file the return for that part here, you won't be able to claim the refund. The issue is that if a person has paid the tax wrongly or advance tax wrongly, he won't be entitled to the interest on that advance tax which has been paid wrongly, because he was not in fact liable to pay that advance tax. And the second thing that he has to wait till the time that he will file the return and he will get the refund order. The department says that instantly you won't get a refund unless you file the return here.
That is, I think, a reasonable condition, sir, because unless you file the return, which is subject to proceedings and assessment, granting refund prior hand or before that assessment or before that return is a kind of procedural requirement which you can't challenge. And you can say that since I paid from my own pocket, direct tax does not have the problem of that unjust enrichment kind of thing. But then requirement of filing return is a reasonable thing to provide for, and I don't think an exception can be taken to that.
That was my question, sir. Thank you, sir. Thank you for the erudite discussion and enlightening us on the complex issue of the Mafatlal.
Yeah.
Can I ask one more thing, sir?
Yes, subject to time limitation, of course. Yes, I think 2-3 minutes. Yes.
Can you elaborate what facts would constitute whether the duty has been passed or not?
That's a very ticklish question, sir. As I said, it's a mixed question of fact and law. So what kind of contract, what kind of business transaction, what is the method of your invoicing, debit, credit, books of accounts maintained in ordinary course of business, etc. All this mixed bag has to be weighed before you arrive at a conclusion whether the incidence has been passed or not. So it will depend upon the facts of each case. Now, writing on invoice, as you said earlier, will not perhaps help. That can be branded as a device to.
No, let us take example of the today's scenario.
Yes.
A GST bill is raised. GST is shown separately because you have to show and separately in the GST bill. So in this scenario, since I have shown GST charged in my invoice, can I say that GST has not been passed? Or in every case where because GST
the moment you raised in the invoice on the basis of that, the money you have received, even if it's end user or customer, he has paid you the full price.
No, suppose customer has not paid the GST amount, though I have charged in the GST bill. So whether that would constitute.
Then raising it invoice means what? Where will you account for it? And you see, it's a trust money, sir. Charging of the tax in the invoice and then collecting or not collecting, not paying to government is an offense.
No, I have paid to the government.
And then you don't take it from your customers.
No, I am just trying to understand what fact would constitute that the tax has been passed on to the customer, or I have borne the incidence of tax.
For a person who is directly dealing with, I think, end consumers, a trader like you, if it's a case of trader, I think you will have no success in saying that incidence has not been passed on. You will not be believed to say that I have not passed on incidence. Even if you say that I said raised X plus 10, customers has paid only X, he has not paid the 10. Now who will run after the customer to verify this? Who will run after you to verify this? Therefore, they will say you believed or you are deemed to have charged X plus 10.
So nobody will be successful in demonstrating
that is why in tax litigation they say after 20 years, if you win, you lose. And if you lose, you already lost.
Thank you. Grateful.
Manoj, can I ask one question to Arun Kumar Agarwal ji?
Yes.
How do you get this background in your...
background?
This is screen setting, sir.
Okay.
You have natural plus some artificial backgrounds.
Yes. This kind of screen is available. You can choose. So it will be available. So whatever actual background is there, it will not be reflected in the.
But his shining top is real, sir. Don't worry about that.
No, that is correct, but because of the light also.
I know. The young man perhaps doesn't know how to change the screen. Your grandson will tell you, sir.
Yes, but I am not that young.
No, I'm talking about Mr. Bajaj.
Mr. Bajaj.
Yes.
Thank you.
Thank you, sir. Yeah, Charu, anything else to come up?
Thank you, sir. Thank you so much for your time and such an erudite lecture on a complex topic that most of us find at least.
Yeah.
But you have actually simplified it and you have beautifully knitted it with the GST with which we are more concerned these days.
I wish
Thank you.
your exam this time has a direct question of Mafatlal Industries. And most of the candidates write it properly.
Yeah, I seriously
Indeed.
hope so.
Indeed.
Thank you.
Thank you so much, sir.
Thank you very much.
Thank you, sir.
Thank you all members of audience for listening to me patiently. Generally speaking, on the screen when there is nobody on the picture, it's like you are speaking to a wall.
Correct.
But if you know that somebody are there behind the wall also, you
Yeah.
may feel some happiness about it.
Right.
And yes, some questions have come. People
Thank you,
have
sir.
joined this, I think, in a bigger number now. How many people are there? 25. Good. So I think people will now see some recordings also. So thank you very much, everybody, and thank you, Charuji, and thank you, madam.
Thank you.
Thank you.
Thank you, sir. Thank you so much.
Thank you, everyone. Good day.
Good day.
Bye.